5 seconds to go. Start. In such circumstances referred to above, the learned Solicitor General prays that the ratio of the decision of this court in the case of Shiva alias Shivaji Supra may either be explained accordingly, keeping in mind the object of the 2015 Act, or the issue may be referred to a larger bench. On the other hand, this appeal has been vehemently opposed by the learned counsel appearing for the respondent accused. The learned counsel would submit that no error, not to speak of any error of law, could be said to have been committed by the High Court while passing the impugned order. He would submit that the decision of this court in the case of Shiva alias Shivaji Supra is binding on the High Court, and the High Court has rightly applied the dictum as laid therein for the purpose of releasing the respondent accused on bail. The learned counsel would submit that if the interpretation put forward by the learned Solicitor General is accepted, then the same would be in breach of Article 21 of the Constitution, which provides that no person shall be convicted of an offence except for one which is in violation of any law in force at the time of commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. The learned counsel further submitted that the scheme of the 2015 Act makes it abundantly clear that it is only if an accused commits an organized crime after the promulgation of the 2015 Act, then the accused can be prosecuted under the provisions of the 2015 Act with the aid of the charge sheets that might have been filed in last 10 preceding years. The learned counsel would submit that unless there is a substantive offence, mere past charge sheets would not constitute the offence of organized crime. He would argue that there is no merit in the contention canvassed on behalf of the appellant state that offence of organized crime itself comprises of charge sheets filed in the past of which cognizance is taken. He would argue that if such a contention were to be accepted, it would amount to giving a free hand to the police to send anybody to a long term of imprisonment merely by filing charge sheets in respect of more than one offence. In such circumstances referred to above, the learned counsel appearing for the respondent accused prays that there being no merit in the present appeal, the same may be dismissed. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only question that falls for our consideration is whether the decision rendered by a coordinate bench of this court in the case of Shiva alias Shivaji Supra requires a relook and the issue be referred to a larger bench. The Gujarat Control of Terrorism Act 2015, as its long title indicates, is an act to make special provisions for the prevention and control of terrorist acts and for coping with criminal activities by organized crime syndicates and for the matters connected therewith or incidental thereto. The statement of objects and reasons contains the reasons which constitute the foundation for the legislature to step in. First, organized crime, which is in existence for some years, poses a serious threat to society. Secondly, organized crime is not confined by national boundaries. Thirdly, organized crime is fueled by illegal wealth generated by contract, killing, extortion, smuggling, and contraband, illegal trade in narcotics, kidnapping for ransom, collection of protection money, and money laundering, and other activities. Fourthly, the illegal wealth and black money generated by organized crime pose adverse effects on the economy. Fifthly, organized crime syndicates make common cause with the terrorists, fostering narco terrorism which extends beyond national boundaries. Sixthly, the existing legal framework in terms of penal and procedural laws and the adjudicatory system were found inadequate to curb and control organized crime. And seventhly, the special law was enacted with stringent and deterrent provisions, including in certain circumstances the power to intercept via electronic or oral communication. 21D, E and F and sections 3 and 4 respectively of the Makoka. Therefore, this court had no occasion to go into that question. This court, however, observed that there was no vagueness as the definitions defined with clarity what was meant by continuing unlawful activity, organized crime, and also organized crime syndicate. This court specifically concluded that after examining the judgment of the High Court of Judicature at Bombay on the issue of the constitutional validity of sections 21D, E and F and sections 3 and 4 respectively of the Makoka, that the court was in accord with the finding arrived at by the High Court that the aforesaid provisions cannot be said to be ultra vires of the Constitution, and this court did not find any reason to take a different view than the one taken by the High Court of Judicature at Bombay while upholding the validity of the aforesaid provisions. Stop.